Hello, Tulare County. I'm your District Attorney, Tim Ward. Wednesday marked the deadline for the governor to sign bills into law, and it was a busy day to say the least. As your District Attorney and an officer for the California District Attorneys Association, I feel that it is important to let you know how several of these bills will affect prosecutors' ability to do their job and what that means for victims of crime as well as the safety of our communities. This year, our office sought to develop laws that would have assisted crime victims, especially those who were sexually assaulted. Senate Bills 853 and 894 failed to ever move forward for a full vote, and the future of those two bills is uncertain. But our proposed bill wasn't the only one to suffer. Senate Bill 1220, authored by Senator Umberg and supported by the California District Attorneys Association, sailed through both houses of the legislature with only one no vote. Unfortunately, it was vetoed with a singular vote by the governor. What makes this extremely disappointing is that this bill would have provided more transparency by ensuring that prosecutors receive information related to misconduct by police officers. As prosecutors, our moral and our ethical obligation is to obtain free and fair justice for both defendants and victims. I'm disappointed to report that a number of bills signed by the governor failed to do just that. Instead, created a confusing and incomplete landscape to navigate. It'd be difficult to review every law passed, but I feel compelled to share a few with you. The first is AB 1950. This law is troubling because it will shorten the length of probation on misdemeanor cases to a maximum of 1 year in most instances. Additionally, in most felony cases, that term is reduced to 2 years. This shortened time inhibits the court's ability to collect full restitution and decreases the window that any necessary protective order could be issued. To me, it just doesn't seem that long ago that justice reform took the position of preferring supervised probation over actual incarceration. Now, to have that time of supervision reduced in this manner, I believe is a disservice to our victims, and it's certainly a disservice to our communities. Next is AB 3070. This new law was called the Anti-Discrimination and Jury Selection Bill. Let me be very clear about something. If you remember any of my words today, please remember this. We abhor discrimination in any form. And that carries over to every single duty that we perform, and not just the jury selection process. While the intent was laudable, the result is very problematic. In a heated rush to, and I'm going to quote from the bill, eliminate the unfair exclusion of potential jurors based on race or ethnicity, the governor signed this law. But this law seems to ensure that a potential juror cannot be excused from sitting on a jury based upon, and I'm going to quote again, expressing a distrust of law enforcement or a belief that law enforcement officers engage in racial profiling. Look, I don't condone police misconduct in any way, nor would I allow a prosecutor to engage in discriminatory jury selection. However, to the degree this new law elevates having an anti-police prejudice to almost a protected status similar to that of race or ethnicity or gender, I fear for the impact on victims who will seek justice in our system across the state. Remember, the constitutional right to an unbiased and a fair jury. How can it be fair that the expression of an anti-police feeling is somehow protected, yet pro-police sentiment can be used to exclude someone without any issues at all? The truth is, this is a complex issue and a complex law, and it's worthy of far more coverage than I can share and address today. But I urge you to review this new law yourself. The last law that I'm going to cover is AB 3234. You may recall we did a press release on this recently. This is a sweeping diversion program for nearly all misdemeanor cases. This includes DUIs, vehicular manslaughters, elder abuse, and even some firearm violations. And what I find extremely egregious is that some crimes against children, such as physical child abuse, are now potentially eligible for diversion over the objection of the prosecutor and over the objection of the victim as well. There's another subcomponent of this bill which lowers the age of elder parole from 60 years of age to 50 years of age, along with reducing the prison term from 25 years to 20 years when you're eligible for that parole. Look, this is yet another early release scheme. It's insulting to victims, and it goes against any of our hope for ever having truth in sentencing. My office and several DA's offices across the state were strong supporters of diversion programs. My office supports programs such as drug court, mental health court, our veterans court program. We even have a diversion program for certain first-time offenders. But as I've said many times before, our local business communities are feeling the impact of crimes such as trespassing, vandalism, and theft. And I strongly believe that these quality of life crimes are plaguing our communities. Sadly, though, this new law will potentially allow for diversion on all these types of cases, regardless of how many repeat offenses have been committed. It diminishes accountability, and it sends the wrong message to our victims, and it certainly sends the wrong message to our business communities, who are reeling right now and struggling to stay afloat. With AB 3070 and other laws passed this session, there appears to be a rush to create laws with a caveat that they can be fixed later. The diversion law is a glaring example. Let me return to the topic of DUI crimes. The governor knew there was widespread opposition from many outside agencies, such as Mothers Against Drunk Driving. Instead of delaying this law to get it right, instead he issued a letter declaring an intent to exclude DUIs in the next legislative session. Why not get it right the first time? Why require a new legislative process, which I believe would need a 2/3 vote to overturn it, and certainly will delay any repair of this law until the summer of 2021, with no guarantee of a change. Effective January 1st of 2021, this version right now takes effect, but I believe next year we can anticipate some costly legal challenges to some of these new laws, as well as a hectic legislative session attempting to rein in this potentially dangerous diversion program. Look, one thing's clear. Sacramento once again shows us that the burden of California's endless social experiments designed to enhance the lives of criminals will be borne on the backs of crime victims and law-abiding residents of California. Thank you for watching, and I hope these few minutes were informative. Understanding that it's a lot of information, we'll post links to these bills below. As always, have a great day, stay safe, and God bless you.